Okay, so welcome to the 2022 Elder Law Update presented by Marshall, Parker, and Weber. I'm attorney Matt Parker. This is the time of year when I try to update those of you working in the medical, financial, and estate planning fields about the hot topics that are affecting our profession. This could include some proposed legislation that could become law, perhaps in the not too distant future. And at the same time, I do hope to entertain you with some insights into a topic that's totally unrelated to our practice. So this year, I decided to become a dog owner for the second time in my life. And this is my new charge. Her name is Mookie. And if you want to know where I got the name, there's this very talented baseball player named Mookie Betts. And he used to play for the Boston Red Sox. That's my team. So plays for the LA Dodgers now. And I thought Mookie was just a great name for a dog. So don't let her cute appearance fool you. She's a real terror. She's just a little over a year old and she's all puppy, gets into everything, anything on the floor and the counter. You got to watch her at all times. So for this year, I've decided to give you some fun facts about our four-legged friends that you may not know about. So, but before we do that, we're going to have to get into some serious content with regards to elder law. And I think one of the hottest topic in the business of elder care in 2022 will be these proposed nursing home regulations. Not only is Pennsylvania rolling out these new regulations for the first time since 1999, but the federal government has also signaled they'd like to have some new federal regulations as well. And a lot of this is, of course, due to the fallout from the pandemic and the rather staggering death toll of so many residents and even workers in the nursing home. They estimate that somewhere in the neighborhood of 200,000 people have passed away. Either they were working in nursing homes or they were residents. So now, Pennsylvania's review and drafting process, in fact, of these regulations began before the pandemic. It started in 2017. Now, the proposed regulations are being rolled out in 5 parts, with each part having a separate comment period. So eventually the Department of Health will roll out these final regulations and once the updates move through the regulatory review process. So this could take some time. So this year, what I'm going to do is just focus on the first 3 sets of proposed regulations that were rolled out in July and October of last year, and most recently in March. Now, the first set of proposed regulations focuses on the quality of care in nursing homes and some regulatory consistency. The most controversial of these proposals is to increase the number of direct care resident hours from 2.7 to 4.1 hours per day. Now, the proposal provides that direct care hours cannot be front-loaded. So they can't be on one shift on any given day, but they have to be spread out over all the shifts. Now, the Department of Health believes that this standard is necessary in light of the quality of care issues that they believe rose during the pandemic. In addition, the Center for Medicare and Medicaid Services, CMS, has long stated that the 4 hours of care was the minimum level needed to prevent issues that arise in nursing homes, such as bed sores, malnutrition, dehydration, and other ailments that can be common in some nursing homes. So according to the Secretary of the Department of Health, just about 18% of the state's nursing homes are currently providing that 4-hour level of care. About 134 of the nursing homes provide between 3.5 and 4 hours, and the remaining nursing homes provide about 3 to 3.5 hours. So basically all of them are currently above this 2.7-hour standard that we have here in Pennsylvania. Now, there were about 150 comments received to these proposed regulations. A large number of them came from people who were supporting the nursing home industry. The industry representatives pointed out that due to a workers shortage in the current economy, they simply cannot hire enough employees to meet this 4-hour proposal. The proposal would require hiring about 7,000 additional direct care workers, and the wages they estimate would cost about $6 million per week, and that was according to the Pennsylvania Healthcare Association. Now, in addition, the Medicaid reimbursement rates for nursing homes hasn't kept up with the cost of care. They haven't adjusted the reimbursement rates since 2014. So many facilities are arguing they simply cannot increase these wages, given this low Medicaid reimbursement rate. And they estimate that under the current reimbursement rate, they'd be paying people about $8 an hour if they had to use the Medicaid reimbursement rate as a way to calculate how much they were going to pay workers. So I found it also very interesting that our surrounding states also have a very low minimum standard for direct care. In fact, some of them, like New York, they don't even have a minimum standard. So at 4.1 hours, Pennsylvania would have the highest minimum in the region. Now, other changes in the first part of those regulations were a lot less controversial. They proposed to eliminate the distinction between profit and not-for-profit facilities in order to ensure that these new regulations are going to apply to all the facilities, regardless of their status. So there's also a desire to provide more consistency between Pennsylvania's definitions in these regulations and those that are rolled out by the Center for Medicare and Medicaid Services. Now, the second set of proposed regulations were rolled out in October of last year. They related to facility closures, and they essentially eliminated some of the notification requirements. They also eliminated some of the financial disclosure requirements that are already required by federal law. And the second set also included some updates in a new chapter to the requirements related to any alterations, renovations, and the construction of facilities. There are going to be separate regulations for new facilities versus existing facilities. From what I have read, these regulations were a lot less controversial. They didn't appear to impose any significant financial impact on the nursing home industry. Now, the third batch of regulations was more recently revealed, and the third package expands the information that applicants for nursing home licenses have to provide. There's more information regarding the ownership of these facilities, financial data, staffing issues, proposed operating budgets, regulatory history. So these requirements will apply to licenses requested for new facilities and changes of ownership for existing facilities. Package also increases the frequency of required facility assessments. There's some new information in there about how bed bugs are going to be treated as reportable diseases. There's updates and requirements related to the prevention of tuberculosis. Now, some of the details in the disclosures include more information about the corporate history, including a lot of the affiliated facilities in the US. There has to be a detailed summary of the current or settled civil or criminal actions these facilities have faced. There has to be information of bankruptcies or other financial failures. So the goal here is to try to root out corporations that are mismanaging nursing homes. Over the years, there's been a shift in ownership in nursing homes from not-for-profit to for-profit entities. And according to our Department of Health, the shift has resulted in ownership structures that are really complex. And a lot of those complexities limits the liability of these corporations. And it's very difficult to figure out who owns a given facility. And sometimes the real property upon which the facility sits is separately owned by the entity itself. And therefore, it's very difficult to understand who ultimately is responsible for the resident care. Now, part of the department, a lot of these leverage buyouts conducted by what are called private equity firms have resulted in sales of the assets of the nursing homes. Consequently, some of the staffing has been reduced in these facilities. And they've seen facility closures. So as such, the department intends to increase the vetting of these prospective owners of nursing homes. Now, the Biden administration's proposal mirrors a lot of what Pennsylvania is trying to implement. The federal proposal would also include greater fines that would be issued by CMS. They want to create a database so they can track facilities owned by the same companies, perhaps, providing poor service. How much of this is actually going to go on and get accomplished during this election year? Who knows? At the federal level, often they roll out these ideas, but they never follow through with them. However, given the unfortunate attention that nursing homes have received during the pandemic, I think we can comfortably, conclude that there is going to be new regulations affecting the industry, at least here on the state level, and that's probably going to happen in 2022. Now, we are still in a public health emergency. It has been renewed by the U.S. Department of Health and Human Services. Thus, those what are called maintenance of effort provisions in the Emergency Response Act will remain in effect, and states like Pennsylvania are going to have to maintain eligibility for Medicaid recipients who were eligible as of January 1, 2020, even if there was a change in circumstances that would ordinarily lead to the termination of benefits. All Medicaid recipients coverage has to continue through the end of the month in which the public health emergency that was declared by the Secretary of Health and Human Services comes to an end. This has resulted in some rather unique circumstances for Medicaid recipients. Many of them, what I represent, have received windfalls that ordinarily would result in the termination of benefits. So my clients are on long-term care Medicaid and the house is sold and they receive the proceeds from the sale of the house, or maybe an inheritance from a deceased spouse, but they're no longer having their benefits terminated, even when the county assistance office is notified. And what we've learned, you do have to notify the county assistance office. If you fail to do that, the OIG gets involved and they can pursue an overpayment in that case. So notification is required. Now, there's been a large increase in Medicaid enrollees in Pennsylvania since 2020. Should this public health emergency end in 2022, tens of thousands of enrollees are going to lose their Medicaid benefits. And it's going to be an enormous undertaking by the state to try and review eligibility for about 3.5 million enrollees after the emergency ends. Now, the Biden administration has promised to give states a 60-day notice before the end of the emergency, so all of you are going to know it's coming to an end. There'll be a notification going out to everybody that this is ending. He hasn't given, they haven't given any notice to this date, so I suspect the public health emergency is going to last throughout the summer. We have had a recent spike in COVID-19 cases in certain states, so throughout the summer, maybe into the fall and winter, this is still going to go on. So the first time since the beginning of COVID-19's the pandemic, nursing homes must allow residents to have visitors when they want under the Center for Medicare and Medicaid Services revised visitation guidance that was issued late last year. If you recall, to curb the spread of COVID-19, CMS issued some guidance in the early days of the pandemic that restricted almost all nursing home visitations with very few exceptions. Unfortunately, this lockdown of nursing homes had the secondary effect of isolating nursing home residents from their loved ones. And I have a distinct recollection, and always will, of having to go visit clients and seeing them through a window from the outside of the building. So once vaccines became widely available, CMS partially loosened its nursing home visitation restrictions. And then on November 12th of last year, they lifted all the restrictions. So under the new guidance, nursing home residents must be allowed visitors at all times without the need for advanced scheduling. Visits may take place indoors, and nursing homes may no longer limit the frequency or length of visits. Nursing homes can bar visitors who test positive or have symptoms of COVID-19 or meet the criteria for quarantine due to COVID-19 exposure. And they still have to abide by reasonable mitigation precautions. I mean, every time I visit the nursing home, they check my temperature, and masks are still required, and so on. Upon return to the facility from short absences, residents can be screened and possibly tested for COVID-19 for absences from the nursing home of 24 hours or more. The guidance suggests that testing the resident and treating the resident as a new admission for the purpose of COVID-19 for purposes of COVID-19 infection prevention is recommended. All right, so as I mentioned, I now have a new basset hound. These dogs were in fact bred with their short legs, they're low to the ground, they have long ears, and they were bred for hunting purposes. The way that the ears and being close to the ground allows them to detect the scent of animals. And back in France, they had these hunts when they would chase and go after foxes. So that's how they use them. And so my dog's sense of smell today can detect just about anything that's in the kitchen. I mean, if there's something really good on the counter, like I'm opening a can of tuna, wow, bananas for that. So she's very good at counter surfing. And remarkably, a dog's sense of smell is between 1,000 and 100,000 times more sensitive than that of humans. The amount of a dog's brain dedicated to the sense of smell is 40 times greater than that of humans. While we have about 6 million olfactory receptors, dogs have a staggering 300 million. Dogs can detect odors in parts per trillion. And to give you an idea, we can detect a teaspoon of sugar in a cup of coffee. A dog, comparatively, can detect that same teaspoon of sugar in an Olympic-sized swimming pool of coffee. That's how much better their smell, their ability to smell is than ours. And their noses function differently than ours. We both breathe and smell through our nasal airways. When dogs inhale, there's a fold of tissue inside their nostril that separates and has two functions. One function is for smelling, and one is for breathing. And then the scent goes into a region of their nose that's totally dedicated to smelling. Now, as you know, dogs are trained to use these remarkable ability to smell in unique circumstances. Some of the jobs they perform are well known. We have drug detecting dogs that are used by police, and they use dogs to help find missing persons. And I just read a few articles where dogs are being used in the Ukraine to detect weapons and explosives. So what I found also surprising about dogs is they can detect an illness in humans. For example, cancer cells apparently release a different metabolic waste products than healthy cells in the human body. And so dogs can detect cancer or other illnesses simply by smelling somebody's breath. So I guess I need to be a little more understanding of my Basset Hound when she wants to smell every single scent she detects on our walks around the block every day. So in the estate planning world, the IRS issued some proposed regulations related to what's called the Secure Act. As I mentioned in prior editions of the Elder Law Update, the Secure Act made a number of changes to how individual retirement accounts are going to be managed. Among other things, the Secure Act relies the starting date for what's called the required minimum distributions from a qualified plan to the age of 72. More controversially, the Secure Act eliminated the so-called stretch IRA to non-exempt beneficiaries. Now the IRA must be distributed within 10 years following the IRA owner's death, rather than over the beneficiary's life expectancy. Now, the Secure Act defined eligible designated beneficiaries for purposes of any exception to this 10-year rule as first, the employee's surviving spouse, second, the employee's child under the age of majority, then a disabled designated beneficiary, a chronically ill individual, or another individual who was no more than 10 years younger than the employee who has passed away. So this year, the IRS issued 275 pages of proposed regulations that can easily put anyone into a state of unconsciousness. I had to sit through a lecture on these proposed regulations, and they were absolutely mind-numbing. However, it's going to take some time for the industry to learn these new regulations as they are finally rolled out. So currently, with these draft proposals, here are some of the highlights. There are a lot of rules relating to the timing of the required minimum distribution, including what happens when an owner or a beneficiary dies before the date that the distributions have to be taken. In some scenarios, no required minimum distribution is required. In others, it must be taken. All these different examples that you're going to have at your disposal and determine what needs to be done when somebody dies. Now, the age of majority for the purpose of being an eligible designated beneficiary is defined as the age of 21. However, they go on to state that the option exists of having these benefit plans use their prior definition, so you don't have to use the age of 21. Now, disability in the proposed regulations is defined, and of course, disabled beneficiaries are allowed to use their life expectancy for purpose of making the distributions. The disability definition depends upon the age of the beneficiary. So those beneficiaries that are under the age of 18 have a much broader definition of what it means to be disabled. And those older beneficiaries have to use the Social Security definition. Essentially, they have to be unable to engage in substantial gainful activity. Now, the regulations also address trusts. The newly released regulations keep many of the rules that existed for trust beneficiaries prior to the Secure Act, such as what they call these look-through or see-through rules for trusts. So if a trust satisfies the look-through rules, then the beneficiaries of the trust are considered designated beneficiaries for determining whether you're going to get the stretch benefit or not. There are some complicated carve-out rules for trusts with disabled or chronically ill individuals. So even if the trust has other beneficiaries that don't qualify, you can sort of carve out that share for the disabled person or chronically ill person and stretch it over their lifetime. And they have the same arrangement for minor beneficiaries in these trusts. So if you find a minor beneficiary, you can carve it out, stretch it over time, whereas the other beneficiaries will have that 10-year rule apply. Now there's a waiver of the 50% penalty when a required minimum distribution is missed after the death of the owner. The waiver is available as long as the beneficiary takes the required minimum distribution by the tax filing deadline, including any extensions. Now, finalized, the regulations would apply to required minimum distributions for the calendar year 2022 going forward. The comments have to be received through the 25th of May. So we're about reaching the end of the comment period, and then they'll eventually roll them out probably either by the end of the summer or early fall. And so what plan sponsors are doing is they're trying to figure out how they're going to communicate these rules to their participants. State planners like myself and financial advisors, we're going to be having to educate ourselves going forward. So there's going to be a lot of time spent in those CLE courses learning about these rules. Here's another slide about them. Okay, so late last year, Governor Wolf signed into law Act 92 and Act 94. Both related to the PACE benefits. PACE is, of course, Pennsylvania's low-income drug benefit plan. Well, Act 92 extended the moratorium on disqualifying somebody from PACE benefits because they got an increase in the overall income due to a Social Security cost of living adjustment. So this extension now lasts through the end of 2023. Now, Act 94 now expands the income eligibility limits for PACENET by $6,000 and removes the PACENET premium clawback, which they believe will result in some cost savings for some enrollees. The PACE and PACENET currently enroll more than 250,000 older Pennsylvanians. The income limit expansion means that an additional 100,000 older adults are expected to now be eligible. And there's expected to be about 20,000 older adults that are going to now enroll just in 2022. So the roles of PACENET are going to increase significantly. If you need to know the income limits for a single person, the income limit has gone up to $33,500. And so if you have a married couple, they can collectively have $41,500 and be eligible. Now, I spoke recently with a client and she was shocked that her health insurance plan had notified her that she was responsible for a very large medical bill related to her husband's care. But the bill was related to care that occurred in more than a year prior to his passing. She and I haggled with the insurance company and got it resolved, but the practice of dropping a huge medical bill on an insured long after the services were rendered is not uncommon, and it's addressed in a new federal law called the No Surprises Act. For people covered under whether you're in a group policy or an individual health insurance plan, you're all going to now be protected from receiving these surprise medical bills under certain circumstances. First, most emergency services are going to be covered. Non-emergency services from out-of-network providers at in-network facilities would be covered, and services from out-of-network air ambulance service providers are covered. Now, there's also going to be this dispute resolution proceeding, and it covers both disputes between plans and providers. And there's also a dispute resolution for the uninsured and self-pay individuals when they receive a medical bill that's substantially greater than what they call the good faith estimate they get from the provider. Now, these surprise medical bills tend to come up when someone receives care from an out-of-network provider. You can be billed by the out-of-network provider for the difference between what your health care plan paid and the bill charge. And that's called balance billing. If you've seen the medical charges for some of these services, they can be quite substantial, especially for the out-of-network services. So if you get your healthcare coverage through your employer, a marketplace plan, or an individual plan purchased from an insurance company, you are all covered by the No Surprises Act. It protects you as follows. There's a ban for surprise billing for most emergency services, even if you get them out of network and without approval beforehand. You cannot be charged more than in-network cost sharing for most emergency and some non-emergency services. Balanced billing is prohibited for certain additional services, like anesthesiology or radiology furnished by out-of-network providers as part of a patient's visit to an in-network facility. Healthcare providers and facilities are required to give you an easy-to-understand notice explaining the applicable billing protections. The notice must state who to contact if you have concerns that a provider or a facility has violated the protections, and the patient consent is required to waive billing protections. Now, if you don't have insurance or you self-pay for your care, these new rules make sure that you can get that good faith estimate of how much your care will cost before you receive it. For services provided in 2022, you can dispute a medical bill if your final charges are at least $400 higher than this good faith estimate, and you file your dispute claim within 120 days of the date on your bill. Now, some health insurance programs already have these protections. So if your clients are receiving Medicare and Medicaid, they are already protected from the surprise billings. Now, for the first time in 4 years, the amount of money that people with disabilities can receive without jeopardizing their eligibility for government benefits is in fact rising. The Internal Revenue Service said that the federal gift tax exclusion is growing from $15,000 to $16,000 annually. That cap also applies to contributions to the ABLE account. Increase, of course, is the first since 2018. Now, ABLE accounts allow individuals with disabilities to save up to $100,000 without risking eligibility for supplemental security income that's issued by the Social Security Administration. Now, Medicaid eligibility can be retained no matter how much is in these accounts. Now, interest earned on the funds in the ABLE accounts is tax-free, and money can be saved to pay for qualified disability expenses. They include education, healthcare, transportation, housing. Now, people with disabilities who are employed can also save some of their earnings in the accounts beyond that gift tax exclusion figure. Now, to be eligible for these accounts, the individuals must have had a disability that began before the age of 26. A dog's tail is basically an interlocking flexible core of bone that's an extension of their backbone. Of course, it's wrapped in muscle and covered in skin. There's a very rich supply of blood vessels and nerves in the tail. And the dog uses the muscles in its tail to make it wag, curl, lift, roll, and turn. Dogs have tails essentially for three reasons. They aid in the balance and the movement of the dog. They help some dogs stay warm. That's one way a dog can communicate with others, including us. So a dog's tail is a lot like our eyebrows. It's responsible for putting out expressions out in, basically, it's beyond the conscious control of the dog. Dogs can control the muscles to make the tail move, but generally it's on autopilot. It's driven by their instinct and how they're feeling at the moment. So when the tail is wagging, what is it trying to tell us? Of course, it depends on the wag. So if you have a nice, big, loopy tail wag, and oftentimes the body is moving with it, we've all seen this when we come home a lot, it's an expression of happiness. They're happy to see us. The fast and shaky wag, highly aroused, very excited and nervous. They have done some studies to indicate the left and the right tail wags have different meanings. To the right means they are in a friendly mood, such as wanting to approach their owner, while to the left means they're not quite sure about something and approaching with caution. Pull down, which I've seen with my dog, particularly around new people, they're not quite sure about something. They're anxious or nervous, and they really gets tucked under them. They're very scared, fearful of something. So when you go home tonight, watch the tails, see what they're telling. All right, last year, Pennsylvania enacted Act 48, adding a new provision to the Crimes Code that criminalizes the financial exploitation of an older adult or care-dependent person by family members or other people who are in a position of trust. Now, this includes any acts that use deception, intimidation, maybe undue influence. Law increases the financial penalties that would otherwise be available. It also allows the Attorney General to investigate and prosecute cases involving funds more than $20,000. Now, essentially, there are 6 categories of people who could be in a position of trust with an older adult or a care-dependent person. And they generally include relatives like the parent, spouse, adult child, a joint owner of property with the older adult or care-dependent person, people who have a fiduciary obligation to the older adult, such as an agent under a power of attorney, maybe a guardian or a trustee, a paid caregiver, a live-in caregiver, such as a friend or a neighbor who has access to the older adult or care-dependent person based upon that relationship. And lastly, a person who is in a current or former intimate relationship. Now, critics have noted these categories are very, very broad, and they could cover all sorts of situations where the relationship's kind of tenuous. People who clean older adults' homes, for example, or perform regular maintenance and commit a financial crime could very well be charged under this section of the law. Now, the penalties are rather severe. They range up to 5 years in prison if the amount involved was under $22,000, and up to 20 years if the amount was over $500,000 or involved in course of conduct involving a loss to 2 or more older adults or care-dependent persons. Now, the new law seems to make a point regarding agents under powers of attorney who are often caught taking advantage of an older adult. Now, the law states that agents are presumed to know the law regarding powers of attorney, and by implication, what acts are permissible when you're acting as the agent for somebody. What can you do or not do with the power of attorney? You're presumed to have this knowledge. Now, the firm's own Jeff Marshall wrote an article about this new law and raised some valid concerns from an elder law perspective. First, there's no really good faith exceptions written into the law, such as those agents who maybe were trying to preserve the assets of the older adult from making transfers out of their name and inadvertently violated the terms of the power of attorney. And so, by implication, if you're going to conduct some asset protection planning for an older adult, maybe you should be using an attorney to guide you. And that might help insulate any charges that the agent was trying to take advantage of this older adult. A lawyer involved, you have hopefully a legitimate plan of asset protection. Now, second, could this law be a disincentive for some potential caregivers? Elder law attorneys have seen older adults make gifts to their caregivers. It's tough to know when the line is drawn between consensual gifts made by the older adult and caregivers who are just taking advantage of them. That's particularly true when there's dementia or Alzheimer's involved. And lastly, for those of you who work for the Area Agency on Aging, you know how dysfunctional families tend to use false allegations to initiate investigations by your agency as well as others. Is this another weapon to be used by a disgruntled sibling to use against the caregiver sibling? Act 48 seems to be a well-intended law, and however, it may have some unintended consequences. Those in a close relationship with an older adult need to carefully consider how involved you're going to become in their financial affairs. Now, House Bill 491 is on track to become law this year. This legislation proposes that federal veterans' compensation and pension benefits will no longer be used to determine a veteran's eligibility for Pennsylvania assistance programs or rebates. It will also extend this exclusion to the veteran's unmarried surviving spouse. Under the bill, all Pennsylvania programs that require the inclusion of an individual's income would be covered. The definition of veteran includes not only those served for one of our armed forces, but also those who served in the reserve or were National Guard participants. And of course, they all have to be discharged other than dishonorable. Now, the veterans benefit payment that's covered on this act includes compensation payments, and I typically deal with the aid and attendance program, or those payments received by the veteran that are as a result of their service-connected disability, typically called pension benefits. Now, a bill that currently has no opposition and may get passed in the near future is House Bill 1693, and that provides for a Medicaid guidance notification to nursing home residents. Many nursing homes and their families are interested, many nursing home residents, I should say, and their families are interested in protecting assets that have been acquired over the resident's lifetime. And of course, they can quickly be spent down given the high cost of nursing home care. And Medicaid can assist with payment for the cost of care, and it does allow for the protection of assets if the appropriate strategies are followed. What we've found in our practice that some nursing home employees and non-legal agencies are providing direction and assistance to nursing home residents with regard to Medicaid applications. These non-legal providers are often unfamiliar with the regulations, the complexities, and the strategies of Medicaid qualification planning. So some of the individuals providing assistance may also have a conflict of interest between their obligations to the nursing home and the resident. And not receiving advice from a professional trained in this area can result in some rather serious financial consequences for the nursing home resident and their families. So consequently, there is this new House bill that's been introduced in order to make certain that nursing home residents and their families are aware of their rights and their options at the time of entering a nursing home. The bill proposes that there'd be this standard notice that we provided to each nursing home resident and their designated representatives at the time of their admission. It would advise them they have the option of having legal representation to assist with the application for Medicaid benefits. All right, so another Pennsylvania Senate bill has been introduced that would amend the Pennsylvania Amber Alert law, establishing the Pennsylvania Silver Alert system to provide notice to the public of a missing person believed to be suffering from Alzheimer's disease, dementia, or another cognitive impairment. That person will be entered into the National Crime Information Center as missing and is believed to be in danger of death or bodily injury. Now, some states already have these systems. This is not a new law that Pennsylvania came up with. These exist across many states in our country. Some of them, as I looked into it, they have like an age-related criteria where you're just over the age of 65 and you happen to be missing. It's totally independent of dementia or Alzheimer's. In addition, some states require the exhaustion of certain efforts to locate the missing person before this silver alert would go out. It's unfortunate, but those who suffer from dementia and Alzheimer's, they're prone to wander. I don't know the actual statistics. I've seen some that say that roughly 1 out of 6 people suffering from dementia or Alzheimer's will wander. But it does occur, and every year we see it in the newspaper or on TV that some older adult is missing, and everybody's starting to look for them. And it happens, unfortunately. So in a controversial move, the Department of Human Services intends to award independent enrollment broker Maximus the contract to conduct medical assessments for older adults and persons with disabilities who wish to apply for government assistance with their care. If you're aware, for the last 30 years, all of the area agencies on aging that service our 67 counties have been performing the assessment and clinical eligibility determination for our seniors and persons with disabilities who are seeking access to Medicaid-funded services. Unfortunately, it appears that unless the area agency on aging is successful in a lawsuit they filed to prevent the appointment, Maximus is on track to assume that role. Now, there have been objections on both sides of the aisle to this change. The primary fear is the delays that will likely be caused in getting services to seniors in the community, perhaps not so much in facilities, but certainly in the community. Maximus has handled enrollment responsibilities for home community-based waiver programs, at least for older adults, since 2016. Recall there were a lot of complaints about poor customer service from advocates, seniors, and state legislatures when they took over this aspect from the area agencies on aging. Now, as an attorney, I practiced in this area for 20 years, and I can confirm that the application timeframe for getting someone approved for waiver services has significantly increased since Maximus got involved. I'm talking about well over a month of additional delay to get somebody on the older adult waiver programs. So why make the change that's likely to further delay getting services to seniors and the disabled individuals in the community? I mean, the state human service officials, as far as I read, they essentially said, well, Maximus was the highest scoring applicant. And they were apparently about to begin contract negotiations. I saw nothing out there that said they have had a final agreement signed. The Area Agency on Aging submitted a right to know request to determine more about what DHS is doing, because it was odd, in my opinion and others. The Area Agency on Aging agencies on aging have filed several protests to this procurement. All of them apparently have been denied. It appears that their last best hope is having success with the appeal to the Commonwealth Court. We'll be following this story throughout the year. I recall my older dog being fast asleep, and then she started to whimper, move her legs as if she was having a dream. She certainly appeared to be in some sort of REM sleep. That's what I thought. I thought she was chasing a squirrel in a dream. So I looked into this behavior, and I found that scientists do believe that dogs dream just like we do. They replay moments of their day when they're fast asleep. They tend to dream about what they do, perhaps chasing rabbits or interacting with their owner. And it's also believed that dogs can have unpleasant dreams, such as traumatic events or being left alone. Now, you can tell a dog has started to dream about 20 to 30 minutes after they started to sleep. Their eyes will begin to move behind their eyeballs. Puppies and seniors tend to dream more than middle-aged dogs. I remember my older basset hound dreaming all the time. They advise that if your dog has started to dream, let the sleeping dog lie. If you disrupt the dog during the REM sleep, it could really startle them, upset them, and lash out in their confused state. So let them conclude that dream and finally catch that darn squirrel. All right, so there was a recent court case involving a power of attorney that demonstrates the problem with using online estate planning forms. So a woman named Mercedes Ghostly owned a home in Pennsylvania. In 2013, she named one of her children, Joseph, as her agent under the power of attorney. And unfortunately, Joseph used a boilerplate form, power of attorney that he found online. It was unknown to Joseph, the power of attorney that he found required Mercedes to be declared incompetent before Joseph could act for her. The powers of attorney can be either immediate or springing powers of attorney. An immediate one takes effect as soon as it's signed. So you sign it today, it can be used tomorrow. A springing power of attorney takes effect only when you become incapacitated. Typically, with these documents, you need a doctor's letter that says you're incapacitated before it can be used. So in this case, Joseph began acting for Mercedes without getting the doctor's letter, certifying that she was incapable of acting for herself. And after he moved into the nursing home, he listed her home for sale and accepted a purchase offer for that home. At the time, his brother, William, was living in the home, and Joseph told William, time to go. I'm putting the house up for sale. Well, William got irritated, and he got a lawyer, and there was a lawsuit. And basically, the lawsuit says, hey, Joseph, you don't have the authority to act for mom because you never got the letter from the doctor stating she was incapacitated. Well, the court eventually determined that Mercedes probably intended to execute an immediate power of attorney. All the facts seem to suggest she was okay with William acting for her and conducting her affairs. She never restricted his ability to act. So ultimately, the court ruled in his favor, but he could have saved himself a lot of time, a lot of money by at least consulting with an attorney before signing the power of attorney, knowing what the power of attorney says before he went ahead and acted as their agent. So the take from this case is that you have to be really careful about using online forms. The powers of attorney are probably one of the most confusing estate planning documents. Nowadays, what one power of attorney will allow you to do will be very different from another one. You have to be very careful when you're taking steps to manage someone's assets. You have to know what that power of attorney allows you to do. All right, a federal court has ruled that hospitalized Medicare beneficiaries who are switched from inpatient to observation status can appeal that decision, making it a lot easier for them to receive coverage for subsequent nursing home care. The ruling does appear to bring to an end more than a decade of litigation on behalf of Medicare recipients. Now, Medicare covers nursing home stays entirely for the first 20 days, but only if the patient was first admitted to a hospital as an inpatient for at least 3 days. That's in part due to pressure from Medicare to reduce costly inpatient stays. Hospitals often don't admit patients, but they rather place them on observation status to determine whether or not they should be admitted. So even if a hospital originally admits a patient, a hospital review board can then switch the patient from inpatient to observation status before or after the patient's stay. Now, if the patient does not have full 3 days as an inpatient, Medicare will not cover that subsequent nursing home stay. It's going to potentially cost the Medicare recipient thousands of dollars. Now, there are other consequences to being considered under observation. Instead of billing you under Medicare Part A, which covers inpatient services, the hospital will bill you under Medicare Part B. That means you're going to owe a copayment for every service offered unless you have a supplemental insurance policy. Your total copayment could be a lot more than the one-time deductible you have under Part A. So in 2011, a group of Medicare beneficiaries sued the federal government in a big class action lawsuit stating, hey, you should have a right to appeal whether your status is switched from an inpatient observation status. You should be legitimately an inpatient, and there's no rights here. So after the case made its way through the court, the Court of Appeals for the Second Circuit affirmed the lowest court ruling in favor of the beneficiaries. Basically said, listen, you can appeal Medicare decisions for lots of other reasons. Why not this one? And therefore, they ordered Medicare, CMS, to set up a process to appeal for coverage as hospital inpatients and to notify people of their appeal. So what do they generally recommend you do now? First of all, advocate for yourself, ask to be put in an inpatient status, go to the doctor, contact your local physician, see if they can have some influence on getting the inpatient status established. So be knowledgeable that this could occur and you need to be advocating. Second of all, if you kept an observation status and you're transferred to a nursing home and denied coverage by Medicare, you can now appeal. Now, in order to appeal, you must wait for what's called a Medicare summary notice. Copy that notice, highlight the disputed charges. The notice should provide information on where to send the notice to request an appeal. You can appeal both the hospital's denials of hospital admission, as well as the subsequent nursing home charges. So how is it that dogs and humans have developed such a close bond? I mean, if you look at an object in the house, a dog will look at what you're pointing. They try to read our intentions. You can't do that with other animals, wild animals. Dogs are one of the most remarkably domesticated animals. You can look in their eyes and they look back at you. They communicate with you with body language. They have, facial cues to communicate with us. They look at us. Domesticated dogs have these facial expressions from raising their eyebrows to gazing at you. So the so-called puppy dog eyes have helped to strengthen the caregiving response. It probably played into our initial desire to associate with them. And there are studies done to determine why dogs give such unconditional love. They found that dogs get a surge of oxytocin when they're around their owners. That's the so-called love hormone. Along with the surge in that hormone, there's also an activation in the dog's brain. It's called the reward center. It occurs when dogs are around or smell their owners. So we use this unique bond between humans and dogs in a variety of settings. Some of you are exposed to that in nursing homes. Dogs are emotional support animals, hospitals as well. Our court system has therapy dogs. Lycoming County Court of Common Pleas just acquired a new black lab to replace the old lab that passed away last year. Service dogs are used to help perform specific tasks. They help a person who has a disability, such as someone who is blind. Therapy dogs, as I mentioned, help people, particularly those with anxiety and post-traumatic stress disorder. They even help children with learning disorders to learn how to read because they reduce stress and improve the concentration. For most of us, they are companions who fill our lives with lots of activities, walking, socialization. Dogs have been known to reduce stress and anxiety and overall put owners in a better mood, most of the time. So here's to those four-legged friends. Our lives would be a lot less enjoyable without them. And I think the office did say we'd have a guest appearance just to make this more entertaining. She's been remarkably quiet.
She's been very.
See. $45 pounds of dog. It's not the last one. All right. So that is the end of the Elder Law Update for 2022. Thank you all for attending. Best of luck to you with your profession. We hope to see you all in 2023.